Welcome to How to Divorce in Custody in California. If you're facing divorce, a child custody dispute, or have questions about California family law, you're in the right place. In this show, attorney Vince Davis and Ms. G break down the legal process into clear, practical steps you can understand. We'll explain your rights, answer common questions, and share strategies that can help you make informed decisions during one of the most important times in your life. And now, let's get started. Hello, everyone, and welcome back. I'm attorney Vincent W. Davis. Thank you for joining us today. If this is your first time watching, I'm a California attorney, and for many years, I've represented parents in family law and juvenile dependency matters throughout California. Today's topic is one that affects thousands of parents every single day. We're talking about child support, more specifically, how do you put yourself in the best possible position when you're involved in a child support dispute? Whether you're the parent paying support, whether you're the parent receiving support, or whether you're trying to modify an existing child support order. Understanding how California courts actually make these decisions can make a tremendous difference. Now, before we begin, I want to say something that's very important. Everything we're discussing today is for educational purposes only. Every case is different. Nothing we're talking about today creates an attorney-client relationship or should be taken as specific legal advice for your particular situation. With that said, let's get started. Today, I'm joined by someone who's going to ask the kinds of questions I hear from parents almost every day. Welcome.
Thank you, Attorney Davis. It's really great to be here because I spend a lot of time reading comments online and talking with parents. And honestly, people seem completely confused about child support. Everyone has advice, everyone has an opinion, but very few people actually understand how California law works. So I thought today I'd ask you the questions that real parents are asking.
Perfect. I think that's the best way to do it. Because if one parent has a question, chances are thousands of other parents have exactly the same question.
Attorney Davis, let's start with the title of today's show. How do you win your child support battle? Is it really about winning, or is that the wrong way to think about it?
That's actually an excellent question. And I think the first thing people need to understand is this. Family court isn't like watching a courtroom drama on television. There's usually no dramatic moment where one parent completely wins and the other parent completely loses. Instead, the court's goal is to make decisions that are consistent with California law and ultimately serve the best interests of the child. So when I say win, what I really mean is this: putting yourself in the strongest legal position possible. That means understanding the law, having accurate financial information, providing honest documentation, meeting deadlines, following court orders, and presenting credible evidence. Those are the things that help people achieve favorable outcomes.
So it's not about who tells the saddest story.
Exactly. And I think that's one of the biggest misconceptions. Many parents walk into court believing, if I can just explain everything that happened in my relationship, the judge will understand. The problem is, the judge isn't there to decide who was the better boyfriend, who was the better girlfriend, who cheated, who lied, who was rude. Those issues usually don't determine child support. Instead, the judge is looking at financial information, income, expenses, custody, timeshare, employment history, tax returns, pay stubs, business records. Those are the things that matter.
That's interesting because I think a lot of people assume child support is some kind of punishment.
Right. I hear that all the time. Someone says, my ex cheated on me, or my ex abandoned the family, or my ex has been terrible. Those things may matter in other legal contexts, but child support isn't designed to punish parents. It's designed to financially support children. That's a very important distinction.
Okay, so if judges aren't deciding child support based on emotions, what are they actually looking at?
California has statewide child support guidelines. Judges don't simply choose a number they think sounds fair. Instead, they start with a mathematical formula. That formula considers several important factors. One of the biggest is each parent's income. Another is how much time each parent spends with the child. There are also other factors that may affect the calculation. For example, health insurance, certain deductions, mandatory retirement contributions, union dues, other court-ordered support obligations, sometimes childcare expenses. All of these pieces may be considered under California law.
If I make twice as much money as my former spouse, does that automatically mean I'll pay twice as much child support?
Not necessarily. Again, it's a formula. Income matters, but parenting time matters too. The number of children matters. Certain allowable deductions matter. Every situation is different. That's why two families with similar incomes can end up with completely different child support orders.
That surprises me. I think a lot of people expect a simple chart.
Exactly. People often ask me, Attorney Davis, just tell me how much I'll have to pay. Unfortunately, it's rarely that simple. There are simply too many variables. That's why it's important to have accurate financial information before making assumptions.
If you had to pick one mistake, just one, what's the biggest mistake parents make in child support cases?
Waiting, without question. People wait too long. They lose their job. They wait. Their income changes. They wait. Their custody schedule changes. They wait. They think it'll work itself out. Sometimes it doesn't. Months go by, even years. Meanwhile, the existing court order remains in effect until it's modified. That's something people need to understand. If your circumstances have changed significantly, you should learn whether you're eligible to ask the court for a modification rather than assuming the order changes automatically.
So, just because someone loses their job, that doesn't automatically reduce child support?
Correct. A job loss by itself doesn't automatically change an existing court order. The court generally needs to approve a modification. Until that happens, the current order usually remains in effect. That's why taking timely action is so important.
Attorney Davis, I want to stay on something you mentioned because I think it's something that scares a lot of people. Let's say someone loses their job. Maybe the company closes, maybe they're laid off, maybe they're downsized. What's the very first thing they should do if they're paying child support?
The first thing they should do is stay calm. Losing a job is stressful enough, but making emotional decisions afterward can make the situation even worse. The next thing is to begin documenting everything. Keep records showing when your employment ended. Save your separation paperwork if you received any. Keep unemployment records. Document your efforts to find another job. If your financial circumstances have changed substantially, learn whether you should ask the court to modify your child support order. One thing I want people to understand is that courts generally expect parents to continue acting responsibly, even during difficult times.
So if someone simply stops paying because they don't have a paycheck anymore, that's probably not a good idea.
Generally speaking, no. A court order remains enforceable until it's changed. Many people mistakenly believe that because they lost their income, the order automatically adjusts. That's usually not how it works. Ignoring the order can result in arrears accumulating, and those unpaid amounts may become very difficult to eliminate later. That's why taking timely legal action is often much better than hoping the problem resolves itself.
I imagine that's something people don't realize until they're already months behind.
Exactly. And by then, they're asking, how did I end up owing thousands of dollars? Often it's because they assumed the system knew they had lost their job. The court only knows what is presented to it.
Here's another question I see constantly online. My ex is hiding money. My ex gets paid in cash. My ex owns a business. My ex says they only make $20,000 a year, but they're driving a brand new luxury SUV. Can someone actually hide income from the court?
That's one of the most common concerns I hear. The short answer is that courts expect both parents to provide truthful financial disclosures. If there are legitimate reasons to believe income isn't being reported accurately, there may be legal ways to investigate that issue. For example, financial records, tax returns, business records, banking information, and other evidence may become relevant depending on the circumstances. Every case is different. Sometimes there really is hidden income. Other times there's a misunderstanding about how someone's finances work. The important thing is not to rely on assumptions. Evidence matters.
So if I walk into court and simply tell the judge, I know he's lying, that's probably not enough.
Usually courts want more than suspicions. Think about it this way. Judges make decisions based on evidence. The stronger your documentation, the stronger your position. For example, if someone claims they earn very little but publicly advertises an expensive lifestyle through their business, that may raise questions. If someone deposits significant amounts of money that don't match reported income, that could also become relevant. Again, every situation depends on its own facts.
I think that's reassuring because sometimes people feel powerless.
They do. But the legal system has procedures for obtaining financial information when appropriate. The important thing is using the proper legal process rather than relying on speculation.
Let's talk about self-employed parents. This seems to confuse people even more. How is child support calculated if someone owns a business?
Self-employment can certainly make child support cases more complex. Unlike someone who receives a regular paycheck every 2 weeks, business owners often have fluctuating income. Some months may be very profitable, other months may not. There may also be legitimate business expenses that don't apply to traditional employees. Because of that, courts often need a more detailed understanding of the business finances.
Does owning a business automatically mean someone is hiding money?
Absolutely not. Most business owners are hardworking people trying to support themselves and their families. Running a business doesn't make someone dishonest. However, business finances can be more complicated than W-2 employment. That's why accurate bookkeeping and complete financial records are so important. Clear documentation helps everyone, including the court, understand the parent's actual financial situation.
So if someone owns a landscaping company or a trucking company or a construction business, the court may need more information than just last year's tax return.
Exactly. Depending on the facts, additional financial documents may be relevant. Again, every case is unique. The goal is to determine an accurate picture of income under California law.
Here's one that's probably going to get a lot of attention. What if someone quits their job just so they won't have to pay child support? Does that work?
It's certainly something people ask about. The answer is that courts don't simply look at what someone earns today. Depending on the circumstances, courts may also consider a person's ability to earn. If someone voluntarily leaves a good-paying job without a legitimate reason, the court may examine the situation carefully. Again, these are very fact-specific determinations. There's no automatic rule that applies to every case.
So someone can't just say, I don't have a job anymore and expect everything to disappear?
Generally speaking, no. Courts look at the total picture. Why did employment end? What efforts are being made to find work? What skills and experience does the person have? Those are the types of questions that may become important.
Another question I hear all the time is about parenting time. People say, if I get 50-50 custody, I won't have to pay child support anymore. Is that true?
Not necessarily. Parenting time is certainly one factor that may affect child support, but it isn't the only factor. Income still matters. Each parent's financial circumstances matter. That's why two families with identical parenting schedules can have very different child support outcomes.
So 50-50 custody doesn't automatically mean zero child support.
Correct. That's one of the biggest myths on the internet. People often oversimplify these issues. California's child support guidelines take multiple factors into account. That's why it's dangerous to assume your support obligation or the support you receive will change based on a single factor alone.
I think a lot of viewers are probably realizing today that child support is much more technical than they expected.
It really is. And that's one reason why getting reliable legal information is so important. Unfortunately, many people make major financial decisions based on advice they read in social media comments. Sometimes that advice is completely wrong.
That's true. You can read 10 different comments and get 10 completely different answers.
Exactly. And while friends and family usually mean well, they don't know the facts of your case. They also may not know current California law. That's why I always encourage people to rely on accurate information rather than rumors or assumptions.
I've even had people tell me, well, my cousin said, and I'll say, your cousin may be a wonderful person, but your cousin isn't the judge hearing your case. Attorney Davis, we've talked about losing a job and changes in income, but what if someone's situation changes months or even years after the original order? Are they simply stuck with that amount forever?
No, not necessarily. One thing people should understand is that child support orders aren't always permanent. Life changes. People change jobs, incomes increase or decrease, children grow older, parenting schedules evolve, and families experience unexpected events. California law provides a process for requesting a modification when there's been a significant change in circumstances. The important point is that the court generally needs to review and approve that request. It's not something that automatically happens because your circumstances changed.
So if someone gets a much better paying job, could the other parent ask the court to increase child support?
Potentially, yes. Likewise, if someone's income decreases substantially, they may be able to ask the court to consider reducing support. The key word is ask. The court evaluates the evidence presented and decides whether a modification is appropriate under California law.
Let's talk about back child support. I've seen stories where people owe tens of thousands of dollars. How does that happen?
Usually it doesn't happen overnight. More often it develops because someone ignores the issue. Maybe they lose their job and stop paying. Maybe they assume the other parent won't notice. Maybe they believe they'll catch up later. Unfortunately, unpaid support can continue accumulating. That's why it's so important not to ignore a child support order. If your financial circumstances change, it's usually much better to address the situation promptly than to wait until the debt has become overwhelming.
So hoping the problem disappears isn't really a strategy.
Exactly. In my experience, avoiding the issue almost always makes it more difficult to resolve.
If someone has a hearing coming up next week, what are some of the biggest mistakes they should avoid?
That's a great question. The first mistake is arriving unprepared. If the court has requested financial information, bring organized, complete, and accurate documents. The second mistake is exaggerating. People sometimes think that making their situation sound worse or making the other parent's situation sound worse will help them. In reality, credibility matters. If the judge finds inconsistencies in your testimony or documentation, it can affect how persuasive your case is. Another mistake is interrupting. Family court can be emotional. I understand that. But judges appreciate people who remain respectful, answer questions directly, and allow everyone to be heard.
I imagine emotions can run pretty high in these cases.
They certainly can. We're talking about children. We're talking about finances. Sometimes we're talking about relationships that ended badly. It's understandable that emotions are involved, but when you're in court, it's important to focus on the legal issues before the judge.
Sometimes it seems like parents start thinking of child support as a competition. I won, you lost. Is that the wrong mindset?
I believe it is. Child support exists to benefit children. It's not intended to reward one parent or punish the other. When parents approach the process as a battle against each other, instead of focusing on what's best for their child, everyone, including the child, can end up paying the price. Now, I understand that not every co-parenting relationship is healthy or cooperative. Some cases involve serious conflict, but even then, it's important to keep the legal purpose of child support in mind.
Attorney Davis, if you could leave viewers with just a few pieces of advice, what would they be?
I'd probably say 5 things. First, understand your court orders. Don't rely on what someone told you or what you read on social media. Read the actual documents and ask questions if you don't understand them. Second, keep good financial records. Accurate documentation is one of the strongest tools you can have in a child support case. Third, don't wait. If your circumstances have changed significantly, find out what legal options may be available rather than assuming things will work themselves out. Fourth, stay respectful. Whether you're communicating with the other parent or appearing before the court, professionalism goes a long way. And finally, remember why child support exists in the first place. It's about ensuring children receive financial support from both parents according to California law.
I really appreciate something you said earlier. You mentioned that winning isn't about hurting the other parent. It's about putting yourself in the strongest legal position through preparation, honesty, and understanding the law.
That's exactly right. People often ask me, how do I win? My answer is usually this: know the facts, know the law, be prepared, be honest, present credible evidence. Those things will always put you in a better position than relying on emotion or assumptions.
Attorney Davis, thank you for taking the time to answer these questions today. I think you've cleared up a lot of misconceptions that people have about child support.
Thank you for being here. And thank you to everyone watching. I hope today's discussion has helped you better understand how child support works in California. Remember, every family situation is different. The information we've shared today is educational and isn't a substitute for legal advice tailored to your specific circumstances. If you're dealing with a child support issue, whether you're seeking to establish support, modify an existing order, or have questions about your rights and responsibilities, it's important to get advice based on the facts of your case. If you'd like to learn more about our practice or schedule a consultation, we'd be happy to speak with you. If you found today's discussion helpful, please consider liking this video, subscribing to the channel, and sharing it with someone who may benefit from the information. I'm Attorney Vincent W. Davis. Thank you for watching, and we'll see you next time.